by the Mental Health Ordinance, Capital 140 of the 1930 Act. This bill now replaces the current law to ensure that mental health care, treatment, and rehabilitation services are promoted widely in Guyana, and that persons receive mental health care in a very high standard. The enactment of this new law will provide the requisite legal framework for readdressing the provision of high-quality care, improvement of access and protection and promotion of human rights, and it also imposes duty on the government to implement policies and measures to ensure the objective of the law is realized. In this way, you can see a diagram of the old mental health law. It is the Ordinance 9 of 1930, and we now have a new law that was the new bill that was passed in April of this year. So basically what I'm going to do is give you an overview of the new mental health law. So the bill is divided into 9 parts. Preliminary, part 1 or preliminary, it has a new title which is changed from the Mental Health Ordinance of 1930 to the Mental Health Protection and Promotion Act of 2022. There's a part for interpretation and the objectives of the act. Now, the objective of this act is to fulfill and protect the rights of persons living with mental illness, to promote the mental health and well-being of all persons in Guyana, to ensure that persons with mental illness receive the best mental health care with the least restriction to their freedom and interference to their human rights and dignity, to minimize the adverse effect of mental illness on the family, life and community, and to address mental health determinants and protect the characters. Part 2, it deals with the promotion of mental health and access to mental health care. Now, implementation of policies and measures. This has to do with the right to accessibility to mental health services, community mental health and rehabilitation, human rights for persons with mental illness, and improvement in the mental health status. Promotion of mental health awareness. This act promotes mental health across Guyana, not only to be centralized in Georgia. There would be mental health promotion policies to address the determinants of mental health, programs to reduce stigma, and all medical personnel, public servants, and police officers, including those attached to prisons, are trained. So it is part of the new mental health law to have these persons trained in mental health. Members of the judiciary and the justice sector to be provided awareness. Many times in the old law, the only time that the judicial system comes into contact with the mentally ill is when they have to send a court order for us to keep them for 6 months. This is, I want to use the word abolish in the new mental health law. A designation of mental health facilities. Part 3 has to do with determination of mental illness, capacity, and consent. So diagnosis for mental illness can only be made to internationally accepted standards, that is the ICU. No person shall be classified as a person with mental illness unless for the treatment or for any other matter under this act and written law. Mental illness should not be determined on the basis of race, religion, political, or social values. Mental capacity to make mental health care or mental health decisions. Every person, including those with mental illness, have the mental capacity to make decisions regarding their care and treatment unless they are unable to understand the information, appreciate foreseeable consequences of the decision, and communicate the decision by speech, gesture, or any other manner. So not merely because you are diagnosed with a mental health issue, it means that you do not have the capacity to make a decision on your own. And that includes your treatment, whether you agree or disagree. A lack of mental capacity shall not be established merely on reference of a person being diagnosed with a mental illness, age or appearance, condition or behavior. when a decision made by someone regarding his mental health is considered wrong, it does not automatically mean that they do not have the mental capacity to make a decision. So they might not make the decision or agree with what you want as the mental health practitioner or the family, but that does not mean that it is wrong. And most times we have persons who maybe they're 90 years old and you have, just because of age, you might have some sort of senile aspect in your behavior. That does not make you lose the capacity. So administer your assets. Informed consent. No person shall administer voluntary mental health care or treatment without the informed consent of the person. So even though you are voluntary mental health care, the person should actually give a written consent to actually accept that mental health care. The informed consent shall be in writing. If unable to write, an oral consent is given, and the psychiatrist shall attest to this in a written form. Whether the court has determined that the person lacks the mental capacity, a nominated guardian shall give the consent. It shall be obtained freely, without threats or inducements, and with adequate information. So we are to explain exactly and for the person to understand according to their level of education. Part 4 of the Mental Health Act has to do with human rights for persons with mental illness. In making a decision concerning the mental health of a patient, the person's will and preference shall be considered. Right to acceptable and good quality mental health services, the right to exercise all civil, political, economic, social, and cultural rights according to the Constitution. Respect human dignity and privacy. These are all rights that the person has. And as Dr. Arthur was saying, in all mental health ordinance, it was actually protecting the community from the mentally ill. Because in some parts of the mental health, the old mental health ordinance, where a medical officer could sign and do that literal certificate, they write a certificate to say that this person is mentally ill. And with that certificate, you are confined to the mental health, to the psychiatric hospital. And sometimes I wonder what sort of treatment was it, because there weren't any antipsychotic, there were nothing. Just imagine you're there in a mental hospital with absolutely no treatment except glucose inhibitor. So you literally were beaten, you were chained, you were chained to like post. You were every morning, and up until recently there was this culture at the hospital, they have to wet the patients every morning. So that's like a form of treatment. Mental health treatment in our country was extremely inhumane, right? And there is something called Asylum Journal that I encourage you to go online and read it. It's about a doctor named Reese. Have you read it? So he was in that it was under the British colony then from 1865 or so 1887, and within that time he had two volumes, volume 1 and 2, and he documented everything that he did. And reading that journal, it actually made me, being the medical superintendent of the hospital, I want to bring it back to that, because there were areas of record, and there weren't any antipsychotics. So as psychiatrists, just imagine how that was. No antipsychotics, no other treatment, but he took the patients out from the chains, right? And he reincorporated and he paid them. The hospital made money by doing therapy operations. They made little things, basket and so on, and they would sell in burpees. And that money come back to pay the patients. So it's not like a forced labor, it's paid labor. And they had a cinema in there, they had a big ball field, they had like everything you could find in a little community, it was there. The hospital space is 21 acres. Right now, only about 2 to 3 acres of that land is utilized. So almost 18 acres is just bush, right? So the history of the hospital is, it was started in 1842, and there are still remnants of those old buildings there. So the history is really, really, really beautiful, and it's a lot of work. And with this here, you would go on to see like all the parts where it's actually parts that protect the patient. So the right to participate in the formulation of the person's treatment plan, not when you come and say, you need this antipsychotic and that's what I'm going to give you. You ask the patient, you get the patient to cooperate, and that's where you get a better outcome. To facilitate the person's reintegration back into the community, the right to be examined in private, the right to appoint a representative. This is a part that we never had, and this is very, very important, because at the moment, let's just say you have a mental illness that you might have a crisis, like for example, schizophrenia. When you're in your lucid moment, you can name a representative. So, and in your moment of crisis, as you are unable to make that decision, your representative can make that decision. And it's not going to be written in stone, because you can go and you can change that representative or alter whatever decision you made for that representative. That it shall not be used for teaching purposes without the previous consent. The right to live and be treated in the community and not to continue in a mental health facility merely because the person does not have a family or is not accepted by his family. Now, this clause in the new Mental Health Act, I am very happy with it, because many times, even we as mental health professionals, we think that because the person doesn't have a family, that means that they have to be in a mental health institution. So you could have a mental illness, but you can function on your own, right? So you can be reincorporated into society and live a very useful life. So abandoned patients with the help of legal aid can facilitate the person exercising their rights to the family home. So many times, we have families who they're like children property. At least this happened in Guyana. And because you have a mental illness now, you lose all that rights. Now the law now protects the mentally ill in that way, so that should you have a mental illness, but you are entitled to part or parcel of your family's property, you can use the legal aid system to actually acquire that property or benefits. Admission to a mental health facility shall not amount to segregation from the community. The right to non-discrimination, the right to confidentiality and access to their mental health records. So the right to confidentiality, there's a clause here because in mental health, especially in cases like for suicidal thoughts, ideation, or plans, there's a little change there in your the right to confidentiality, because in this case, as a person, and more so as a medical personnel and as a mental health personnel, you have to disclose. You tell the person before prior, I have to disclose this. Information. The right to least restrictive alternative, the right to knowledge of their rights, access to justice on an equal basis with others, the best interest of a child is a primary consideration. His wishes must be taken into consideration when practical. Part 5 deals with the nominated representative and guardianship. The right to make advance directive and appoint a nominated representative, which can be revoked, amended, or cancelled at any time. The appointment of a nominated representative must not be construed as lack of capacity. So someone can have the capacity, but they still nominate someone as their guardian or their representative. Reviewing, altering, or modifying or cancelling of the advance directive by a caregiver can be done through the application to the High Court. When a person lacks mental capacity, the High Court on application can nominate a guardian. The guardian has the power to deal with the estate of a person with mental illness. Part 6 deals with care and treatment of persons with mental illness. Admission of persons with mental illness. The admission of persons with mental illness should only be when home care cannot be done. When admission is required, it must be done on a basis of voluntary admission. When a person lacks capacity, care may be provided at a mental health facility. Voluntary admission. Any person who considers himself to have a mental illness can voluntarily admit himself to a mental health facility. He may apply in writing to the medical director. So one of the changes from the old mental health ordinance to the new mental health act is that in the old mental health ordinance we have this where, because neurotic cases can't admit themselves, but they have to pay, and that was up to prior to April. I was still aware of that, but you have to pay if you want to be admitted. If you come ask for admission, so that is out of it now. If the person lacks capacity to understand the purpose and nature of this purpose treatment, the person shall not be admitted. So the person doesn't understand what admission to this hospital means, they will not be admitted merely because they want to be admitted. So I don't think we have that problem mostly in Guyana, but in Cuba we have that a lot, because working as a psychiatry resident in Cuba, people come and demand admission. It's the opposite in Guyana. If a person reaches criteria for involuntary admission, the medical director may prevent the self-discharge. A person who voluntarily admits himself can discharge himself. But if during that period of voluntary admission he becomes unwell, it can then go to the mental health board and make it into an involuntary admission. So then, on the other hand, cannot discharge themselves. Involuntary admission. A person who lacks mental capacity, involuntary admission would be for a person who lacks the mental capacity. An application can be made by the nominated representative or guardian, or any person who in the preceding 7 days prior to the admission, 1, threatens or causes bodily harm to himself, behaves violently, may cause another person bodily harm, and show inability to care for oneself, placing them at risk for harm. So these are the three requirements for an involuntary admission, and it has to be within the 7 days prior. So now 1 month ago you were behaving abnormal, and now they brought you, you're okay, and I want to admit you. It has to be within that 7-day period. The medical profession who makes the assessment shall not be related by blood or marriage to the patient. So, as an involuntary admission, if you have any tie with the patient, be it blood or by marriage, you cannot be the person who will be doing that involuntary admission. Involuntary treatment. When involuntary admission is granted, a psychiatrist may assess the physical and mental needs of the patient and report to the Chief Medical Officer. After 72 hours, a new application for involuntary admission must be made. A person with mental illness may appeal to the board against the decision of the medical director in voluntary admission. Any person who is dissatisfied with the board's decision can appeal to the High Court. So that is one thing that we didn't have before, and we are working right now to institute a mental health board. Right? That's a part actually of the new mental health policy. A medical practitioner, upon the request of a guardian, shall visit a person who is mentally ill at home and who warrants treatment. A police officer may convey to a health facility any person with mental illness wandering in a public place. Emergency treatment can be provided by any medical practitioner without informed consent to prevent 1. Death or irreversible damage to other person or serious harm to themselves. So involuntary treatment on an emergency basis can be done by any medical practitioner, but when it's a non-emergency case, it's only supposed to be done by a mental health professional. Emergency treatment shall be limited to 24 hours. 3 months review for all involuntary admission by the board. If you're admitted by an involuntary, through an involuntary admission, it has to be reviewed every 3 months by the board. Admission of a person with mental illness on the court order. It is sufficient authority to admit to receive mental health care. So a court order is sufficient authority. The court has the authority to admit for mental health care. The court, before making the decision, calls the person to be assessed by a psychiatrist. This is one of the differences we have in the old mental health ordinance, because they have the power to direct the person to the mental hospital for a period of time that they feel necessary. And sometimes, well, all the time, it's never done upon what the psychiatrist said, because many times we have to keep patients for 6 months, and within 2 days, the patient is perfectly okay. An admission by the court shall be regarded as an involuntary admission. Prisoners with mental illness. The director of prisons may make application for treatment of an inmate. It can be treated as an outpatient, voluntary admission, or involuntary admission. Time spent in a mental health facility shall be treated as time spent in prison. Seclusion and physical restraint. Patient shall not be subjected to seclusion. So putting the patient in a single room is a no-no in the new Mental Health Act. It shall physical restraint only to prevent immediate harm. And when physical restraint is used, it should only be used until chemical restraint is it shall not be done. It shall only be done in a mental health facility. So you cannot do a seclusion because obviously it will be like maybe more than 24 hours. So the seclusion should only be done in a mental health facility. And it should be authorized by a psychiatrist or a practitioner with expertise in mental health. It should not be used as a form of punishment. And physical restraint should only be for a maximum of 3 hours. Part 6, the mental health board. So the mental health board, we are currently working to make the mental health board. It would be with 11 members, a psychiatrist, someone from Human Services and Social Security, a person nominated by the medical profession, a human rights specialist, the chief medical officer, a family member or user, an attorney at law, a social worker, a clinical psychologist, the chief nursing officer, and a user of a mental health service, a user and the family of a mental health service. Part 8, offenses. Cruelty, abuse, and willful neglect. Commit an offense is liable to a fine of $1 million or 6 months imprisonment. So cruelty, abuse, or willful neglect of any mental health or mentally ill patient is a criminal offense, is liable to a fine and or 6 months imprisonment. Abandonment of a person with mental illness. Who intentionally abandons a person with mental illness commits an offense and liable to a fine of $1 million or 6 months imprisonment. Interfering or obstructing. Anyone who interferes with duty of the medical practitioner faces $500,000 or 6 months imprisonment. So sometimes there's a patient who is severely mentally ill. They come to the hospital and the family says, I do not want treatment. Right? Or something, they take the family and the patient, and that person lacks capacity. The patient lacks the capacity, and the family member who is not their guardian or representative make that decision. That would be obstructing the treatment of the patient, and it is liable, it's a criminal offense. Willfully makes a false or misleading statement, commits an offense, faces $500,000 or 6 months imprisonment. Dr. Zenia, do you remember the case of the boy who the family, he had absolutely no mental illness. The mother, it's a domestic problem with the boyfriend, the boy and his girlfriend, and the mother likes one girl for the other, and the boy chose the other. And she went to the court, the mother went to the court and got a court order to admit that person to the hospital. And we were, because I was there attending, and it was a dilemma. What do we do? Because we cannot go against the court order, but this is a perfectly sane person, but there's an order to admit. So in a case like this, one, the court cannot send because they have to be previously examined by us, and two, it would be an offense on the person who went for that court order. So admit that person to a mental hospital. Ignorance of victim's mental state is not a defense. So it shall not be a defense for a person who is charged under any of the provision of this part that the person did not know the person was suffering from a mental illness. So example, a patient with bipolar disorder. Let's just see. So those patients sometimes they're very hyper-erotic. And if the person who seems very okay, they're in a manic state or hypomanic state, if someone has sex with that patient, it is a criminal offense. In fact, it's a criminal offense for most part of the world, but in Guyana, it now states that it is a criminal offense. Part 9 has to do with some miscellaneous clause, and the clause 69 of this act of the Mental Health Protection and Promotion states that the Mental Health Ordinance of 1960 is written. Thank you.
Is this text somewhere available on how you get it? On the internet, or can you get it? Or do you have to buy it, or if you want to buy it, where do you buy it? Sorry?
Yeah, but Parliament. They were one part they were waiting for the president to make his signature, and I think that's finished right now, so it's already enacted, and the Minister of Health would be this person that.
The second question, does it have a sunset clause?
Sorry?
I was asking whether it had a sunset clause. Most of the rules about mental illness, because of the fast development of thinking and knowledge, have a sunset clause. It says this ordinance is valid until the year 2030, at which point it has to be examined again. Yeah. That is very important because it puts it automatically onto the agenda of the legislative body, which has to be examined and say, yeah, all right, no, it is not. Yes, please.
Person with mental illness, sometimes in our system, are housing authorities. And there's a mixture in the housing between persons who are traumatic and persons who are genuine sick mentally ill. And that causes contrast. Because sometimes these persons with addiction, they have weapons and they can attack. So that's something.
They don't have weapons at the hospital. They do constant checks.
They
We have to go quick, just a minute, yes, please.
Yes, sorry. So one is the hospital was made originally for 95 beds. Over the years, it went on to 150 beds. As it is right now, it's 214 beds. So there are 9 wards or chalets that we would call them. So these patients, as it is right now, they are less than maybe 40% of those patients are psychiatric patients. We have cases in there who are like they're there for more than 30 years. We have patients who born in there and they lived all their lives in there, right? So there is a problem with we don't have a good categorization of persons, like to see who are geriatric cases, who are neuropsychiatric cases, who are substance users, or who are purely psychiatric cases and so on. So we are working towards getting that now, but we have a problem with overcrowding, and that's what's actually caused and understaffed.
Appreciate it.
Just a quick question. I'm an organization psychologist, and what I recognize in this law, there's nothing in this new law. There's nothing in place for employee-employer. Here, why I ask that: if someone is, let's say, suffer from depression, up at the manic stage, right? I'm going to give you a classic example. There's a person, an employee that I engage with, who has seizures, right, because of head injuries, and that person suffered from depression. Now, that person would have asked to not be exposed to certain content because when that person becomes depressed, the seizure comes on. Now, how does this law protect an employee like that in the context in the corporate space? Because there was a lot of fighting back and forth, orders of dismissals and suspension, because that person said, here's a track record. If you check my sick leave, you will see that I would have been on sick leave for seizures, and this is what brings it on. I cannot be exposed to this content. So, with what this gentleman said, that clause at the bottom should be there, because it would be, this law would need to constantly be reviewed and updated, so that it involves a wide classification of course. But as we speak, I work in HR, and there's nothing to protect people who has mental illness challenges within the workspace.
So, the mental health board, that's one of the functions of the mental health board. So I agree that there should be that clause, as the doctor was talking about. We should have that clause yet, but those aspects are in the duties of the mental health board. It is their action. Able to be with the persons who may be unable to work and fired because of mental illness and so on is protected in the
Well, how do we get
Gentlemen,
employers
we'll
to?
have to discuss this later, please.
I really want to know if the mental health is institutions or for the world.
It's for the country.
For example,
This law is for the country.
You have a question.
I was just trying to support the gentleman's thoughts. So you did say, you did have that we need a lot of work done. I would agree. We have persons who can be rehabilitated within a short period of time, being thrown together with persons who have been in there, like you said, over a number of years, taking advantage. That's how we're having works within the hospital itself. The entire security system there is flawed. The administration is flawed. I'm saying this because I've done a stint through the university with them. I made recommendations over the years when I spoken with this new we can see some changes. Because persons are going in there, they can be rehabilitated. Unfortunately, they do not come out of this rehabilitation. So thank you for saying there's a lot of work there.
We have two more comments that I would like to mention to you. One is she didn't mention, but which is important, is the current decision, and Guyana is one of the signatories of the Convention of the Rights of People with Disabilities, which is very much in harmony with what you have shown. This convention, in fact, considers that mental illness is also a disability, right? And no person with disability may be applied treatment, which is another aspect that is very important, without the permission of the person. Maybe another fact of interest is that the human rights have only been invented after the Second World War. They never existed in the history of mankind. It's after the Second World War they suddenly discovered that they must protect the human rights in general. They never existed. Very question.
Two quick points then. I think after the act, we enter into the supplementary phase. So it's good that people have comments like that. I think we need to put them together so that it can be sent, so that that supplementary phase, we can have that. The second point, I think someone was asking whether the presentations are available or maybe they are. The act, I'm not sure, but the presentations, because they are being streamed, you will have it on our site. Even last year's own are there, so please feel free to refer your friends, to go and listen again.
Time is unfortunately come. I want to thank you very much for your presentation and for your good luck with the law and good luck with the community care. Thank you very much for your attention.